When you have multiple injuries, multiple problems, that people's problems go up by multiplication, not by addition.
TBI cases can feel like navigating uncharted territory. Your client's injury is real, but proving it, that's where the real challenge begins. If you've ever felt like you're missing crucial pieces of the puzzle, you're in the right place. Welcome to Winning the TBI Case, where Tom Crosley shares the insights he's gained from over 60 injury trials. Not just the victories, but the lessons learned along the way that make all the difference. Winning the TBI Case. Strategy, science, and storytelling. In this episode, Tom sits down with nationally recognized trial lawyer, Steve Gursten.
Welcome back to Winning the TBI Case. I'm your host, Tom Crosley, and today we're joined by Stephen Gursten. Steve is Michigan auto law, and he's a nationally recognized trial lawyer, consistent top 50 Michigan attorney voted by his peers. He's a past president of the AAJ TBI litigation group, among other AAJ groups. He's currently leading AAJ's distracted driving litigation group. And today, Steve and I are going to talk about what it takes to win these cases. Steve, how are you today?
Hey, great to see you, Tom. I'm doing great.
Would you give us some background about yourself and what got you into TBI litigation in the first place?
Sure. So I was lucky enough, in a Malcolm Gladwell outlier sort of way, being in the right place at the right time, to become a lawyer in 1995, which is now 30 years. The reason I consider that so lucky is that was when Allstate and then State Farm, shortly after, started their MIST, minimal impact soft tissue programs, where for the first time in like a generation or two, lawyers were actually being forced to go to trial and try these low vehicle damage soft tissue cases. It was, for me as a baby young lawyer, the greatest thing I could have asked for, because literally 2 weeks after I passed the bar, I'm trying my first case, and I got a ton of great, invaluable trial experience right away. And the reason I think that's so important is one of the things that we always need to think about when we're in a profession where the supply of lawyers is always much greater than the demand for those lawyers is, how do we separate ourselves, right? How do we make ourselves remarkable? How do we make ourselves stand out when you've got thousands of other lawyers in your venue that are all marketing for the exact same kinds of cases? As I was trying these cases, I developed a reputation for getting hot grounders from other lawyers. And those would be the cases, you're smiling because you've been there too, where it's like 3 weeks before the trial and that lawyer finally dawns on him or her that they're not going to be able to settle this case. And they gave it to me for trial.
I love that phrase, hot grounders. I knew instantly what you meant by it, even though I'd never heard it used in that context.
Yeah, no, I mean, hot grounders will age you a little bit, but they are a lot of fun and a lot of experience. So, but one of those cases was a really interesting, mild traumatic brain injury case where a woman had been involved in a car crash and had continued to work for 8 months after the crash. And as you know, there are a couple of reasons why we tend to lose these cases. I think delays in diagnosis and gaps in treatment are probably two of the very biggest. And the lawyer who referred it to me felt it was an unwinnable case with 8 months of continuing to work and getting pretty good work evaluations, that there really wasn't a way that we were going to prove that she had an impairing brain injury. And fortunately, in Oakland County, Michigan, which is a very conservative venue, a jury felt differently and awarded $4.2 million. And I was I think I was a year and a half into practicing law. And what that led to was a lot of lawyers now all over the state that started referring me their brain injury cases. And really, that's how I got really involved in brain injury. I got thrown in the fire and had some early success, and then kind of just became the lawyer that lawyers referred those cases to in Michigan.
I love that story, especially the part about it's a hot grounder. It's a case that somebody else thought was not winnable. You're still a baby lawyer. And I'm sure, what was the pretrial offer? Was it Allstate or State Farm or one of those?
It was through General Motors, because it was a General Motors test vehicle, which is great because that meant I actually got paid on the case too. Uh, and the highest offer, so the offer was basically zero going into trial. And we did really well at trial. The offer, when the jury was deliberating, was $100,000. And the jury came back at over $4 million.
That's amazing. That's great. So 42x of the best offer during deliberations and infinitely better compared to the pretrial offer. So,
but it goes to the point that you and I always make when we teach at seminars, which is you have to be willing to try these cases too, because adjusters and insurance companies will always under-evaluate the full value of these cases. So you have to try them.
And that's always been true. I think it was probably even more true back then because people didn't know. I mean, still today, insurance companies have difficulty evaluating a TBI case. I mean, I've talked about this a lot in terms of you can't use past medical expenses or even future meds as a barometer to gauge the value of a TBI case.
Nor should he, by the way. When you talk about what the future holds and what the peer-reviewed literature shows these people are so much more susceptible to now with dementia, Alzheimer's, Parkinson's, divorce, suicide, everything. I think using past medicals is really misleading in terms of what the future really could bring to these people.
I want to dive a little deeper into the case you tried. What year was that first TBI trial with the big result?
So I became a lawyer in 95. So let's say 96 or 97.
And so what was the evidence like back in 96 or 97? We didn't have advanced neuroimaging readily available to us. How did you prove the existence of the TBI?
Right. So it would have been neuropsychological testing back then, because back then we didn't really have much else. We were just experimenting with SPECT scan at that time, single photon emission computerized tomography. I don't remember, honestly, if we did a SPECT scan in that case or not. It's been 29 years, but those probably would have been the two ways that we proved it, along with, a psychiatrist or a neurologist, whoever would have been the group that were providing, rendering treatment for her.
Yeah. And so, all right, so that makes sense. You hit this big lick. Other lawyers now view you as the TBI guy. You start getting lots more cases and probably lots more opportunities to work these cases up. So how did that evolve over the years?
That's a great question. So let me first put in a plug to the AAJ Traumatic Brain Injury Group. Whether it's AAJ or any TBI seminar, the message that I always try to get across is so much of the medicine and science is counterintuitive in these cases. And you really have to learn. And one of the things that I think separates lawyers like you and lawyers that do very well in trial on these kinds of cases from those that don't is they actually spend the time learning the medicine and the science. You have to spend hundreds of hours learning the stuff and going to seminars and reading the books and reading the journal articles and really mastering your trade. I don't know why lawyers somehow think we're different from every other occupation in this world where, this is our craft, this is our trade. And that means you really should be excellent in terms of your knowledge of the medicine. And, there's so many ways that that's helpful. When you look at malingering, for example, which is always an issue in these cases, how do you effectively cross-examine or prove that these malingering tests are invalid or that they're being used improperly, or explain the real context in which they're being used, which is deceitful, unless you understand the underlying tests and the medicine? Even something as simple as loss of consciousness, Tom, right? There's always a dispute whether there's a loss of consciousness. And, the reality is we can explain to a jury till we're blue in the face, or to more likely a cynical insurance adjuster till we're blue in the face, that you don't need a loss of consciousness to have a brain injury. But guess what? If you're asking for $10 million, the jury's probably going to think you need a loss of consciousness. So you just need to be able to look at these cases and be able to truly analyze them from the plaintiff, who's 50% of these cases. And I think we do as a general rule, we make a lot of mistakes when it comes to that. There's I think a Texas expression, 3 fleas and it's a dog. But I do believe that that's a really good concept to keep in mind before you spend $80,000 to $100,000 of your money trying these cases. I don't listen. There's no such thing as a perfect case, and if you're going to be a trial lawyer, every case is going to have a couple fleas. The question is once you get past that 3rd, 4th, 5th flea, is this still a case you want to try? Versus maybe trying to settle and picking another case to spend all your time and money on.
I have so many questions I want to ask you, but let's visit this. Let's visit this concept of 3 fleas and it's a dog. So when you say 3 fleas and it's a dog, you're talking about case selection criteria, right?
Yes.
And so how are you teaching the lawyers in your firm this concept when it comes to a TBI case?
So the first thing, because it goes back to what I was saying a moment ago, I believe gaps of time and delays in diagnosis kill these cases. So the most important thing is to be on the ball as quickly as you can in terms of trying to make sure there is something in the medical records with a diagnosis of TBI. And by the way, we're fortunate nowadays because unlike when you and I first started our careers, as far as I know, every discharge instruction from every emergency room now in the United States basically gives people a list of about 20 or 30 things they should be on the lookout for. Things like continuing to have headaches, problems with memory, concentration, attention. Are they tired? Are they getting nauseous? What have you? And it says in bold is if you're having any of these symptoms, come back to the emergency room right away or go immediately to your family doctor. So already the seeds are there to develop that logical connection between the trauma and hopefully getting them that diagnosis right away. That to me is probably most important. Now it gets much harder because like you, a huge number of my cases are attorney referrals. So if it's a year or a year and a half down the road, now you're dealing with judo law and how to, maybe put lipstick on a pig and try and maybe change the storyline in a way where you can still present that evidence. But what I try to do in those cases is maybe instead of making it that uphill battle now, especially where you have 8 months or a year that went by,
right?
No diagnosis of TBI. Let's face it, if you're going to ask for $10 million on that case and you got a year delay before there's any diagnosis, jury's going to give you a hard time probably. You're going to come in second place most likely in that case. What I do in those types of cases is I try to flip them into more of an acquired traumatic brain injury case, where instead of fighting that uphill fight of saying, no, there really was a brain injury, it just wasn't diagnosed for a year, I try to turn it into more of an umbrella diagnosis like chronic pain syndrome, where you then make the problems that your client is having with things like memory, concentration, attention, all the classic TBI problems, all those things that a jury would really have a hard time accepting from a brain injury a year ago that was never diagnosed, they're much more likely to accept it if you're saying it's from exposure to chronic pain. And it's that exposure to chronic pain combined with fatigue and sleep deprivation and that vicious downward cycle where all these symptoms now start to interact, which is what the human body, what happens to us, right? We have to understand that when you get hit by a car, when you get hit by a truck, and you've got multiple injuries, it's not just your back injury and surgery. It's not your rotator cuff. It's not your headaches. It's not your tinnitus. It's not the sleep deprivation. It's not the fatigue. It's all those things. And then it's that interplay, that vicious interplay, that downward cycle that a lot of people get caught up into where they spiral out of time. And defense doctors always like to say they're malingering because people should be getting better, not worse over time. But the science and the medicine says the exact opposite. That in real life, when you've got multifactorial injuries and lots of problems going on, there's always one that is it's like throwing gasoline on a fire. The fatigue and pain are accelerants, and they make everything worse. So that jury that might be predisposed not to want to believe that it's a undiagnosed brain injury, they're much more willing to accept it if it comes as part of a larger umbrella diagnosis of chronic pain syndrome, for example. So that's what I try to do in those cases.
So I can't tell you how many times, Steve, in my career that I've gotten a case a year and a half after the injury and wished I could turn back the clock and have it 3 weeks after the injury, because then there would be consistent follow-up medical care, documentation, symptoms, things like that. So, but I haven't thought about recasting the entire case a year and a half later as a chronic pain case. So I'd like to talk a little bit more about that. I remember in 2018 or so reading some literature that said long-term exposure to chronic pain causes changes in the brain.
Exactly.
Similar to like a post-concussion type syndrome. And I don't think I had the right case to work that issue up, but it sounds like maybe you have. So I'd like you to explore that a little bit with us.
Sure. So it's just like you said, that once you have exposure to pain that is chronic, meaning it meets the DSM definition of chronic, which is over 6 months, then what we are learning, what the science now shows, is that exposure to pain in and of itself can cause chemical, organic, and structural changes to our brains. And it's interesting. There's a world-renowned neuroradiologist, Aaron Bigler, right now. When I last heard him speak, when I went out to speak to the Utah trial lawyers in Salt Lake, he was there presenting as well. And he was doing serial DTI, Tom, on people's brains who had never been diagnosed with a brain injury, but who had been exposed to chronic pain, and showing how their brains are changing over time just from exposure to pain. So it's out there. And, I'm not saying you need to do a DTI in every pain case, but what I am saying is, guess what? The way the science is going, 5 or 10 years from now, we may be doing that, and we may be, for the first time ever, being able to objectively show how pain is literally damaging our clients' brains and the effect it's having on their bodies long term. So I think this is I honestly can't think of anything that would change our profession more than being able, for the first time in our careers, to be able to objectively prove pain. So, so that's out there. The literature is there. There's, as I last looked, I think about 60 or 70 peer-reviewed journal articles that all talk about the same mind-body connection that, we've always known, actually since Descartes, that, our brains affect our bodies. But now what we really know from the science is that our bodies also affect our brains. So when you're like me and you've got a case where someone was rear-ended by a truck, or, broadsided by a car, and they've got multiple injuries, sometimes I just think it's easier to, again, instead of fighting that uphill battle of trying to, get that round peg in a square hole, which is going to be just intuitively difficult for juries to be able to understand and return a large verdict on, change the frame of your story to something that is much more something they are willing to accept, and that is more intuitive with what they would expect of someone who's had serious injuries, physical injuries, and surgeries. So, I will tell you, we've now had, so this is not just talking the talk, this is walking the walk. We've now had 14 separate jury verdicts. They're all over $1 million on defense offers of $30,000 or less. And, wow. And what that tells you is that insurance companies are misevaluating these cases, looking at them as these fudgy TBI cases, and essentially offering the cost of the defense. And what I'm saying is, look, if you've got a really likable, good plaintiff and you have good injuries with good doctors that will support your case, then go and take a shot on those cases. Because if the jury believes them, you're probably going to end up with a 7-figure verdict, or at least, significantly more than the $10,000 or $50,000 or $30,000 that the insurance company is offering that doesn't do anything for your client and doesn't do anything in terms of moving the needle. So you may as well try that case.
Yeah. So I tell young lawyers when they ask me, what's the value of a case? I ask a question. I say, well, how good is your Exhibit A? And they look at me and you know what I mean, right? Exhibit A is your client, and a good client.
That's why I started laughing. Yep. It's always Exhibit A.
All right. So I'm curious, when you're working up the case from a chronic pain standpoint, it sounds like a multifactorial inquiry, right? There's probably multiple experts or doctors or treating physicians or some combination that you're using to clear that hurdle. So can you talk about that?
Yeah. So where I think most lawyers and doctors really do a disservice on these cases is because medicine now is so specialized and subspecialized and subspecialized. Every doctor is only interested in their own very narrow specialty. So you have these situations occurring that you and I see all the time, right? Where you may have a neurosurgeon, but they spend 100% of their time doing spine surgery. They never even bother to do even a 5-minute evaluation for mild TBI. And then you get 8 months later, a really skilled defense attorney who will use that to try to really hammer your case. And juries that are nodding their heads saying, yeah, why didn't the neurosurgeon diagnose TBI? And it's every medical field. I mean, neurologists are a great example of this. And they're infuriating, by the way, because, you could have a neurologist that sees 20 patients in a day, and 19 of them are MS and seizure disorders, and they really don't do any diagnosis and treatment of TBI. So they're not even evaluating for TBI. Or if they are, they're just, they'll do a neurological exam, a mini mental status exam, which is, again, less than 5 minutes and doesn't rule out even a moderate TBI, let alone a mild TBI. So what happens is the way medicine is practiced today, it is failing so many of our clients. And then lawyers make it worse because when we go to court or when we're talking to the defense attorney or the adjuster, and they're saying, well, what's your case about? And we say, there's a back injury, there's a shoulder injury, there's tinnitus, what have you. There's 6 months of TMJ. And we're losing the total picture, the cumulative effect on our clients. But what is real life? And real life is the cumulative effect. It's not those individual injuries, because those individual injuries are not static. They all influence, impact, and in many cases can make worse other injuries and problems that people are having. So to bring it to life, I really love to have a great PM&R, someone who could take a step back, look at the total physical condition and mental condition, the mind and body of your client, and really talk about, well, I'll give you an example. One of my favorite doctors, physiatrists, what he says when he testifies is you have to understand with the human body, 2 + 2 does not equal 4.
I like that.
Yeah, that when you have multiple injuries, multiple problems, that people's problems go up by multiplication, not by addition. That's really profound, but that also reflects where we're at today with the medical literature and the science. So it's getting away from the artificial constraints of how medicine is being practiced right now with these really rigid specialties and focusing more on the real life impact that these injuries are having on our clients.
That's good. I was thinking the 2 + 2 does not equal 4. And it's more like 2 × 2, which also equals 4. And the trial lawyer advocate in me was thinking, okay, when I prep that witness, we're going to use 10 plus 10.
Yes, or 4 times 4, right?
Right? 10 plus 10 is 20, or 10 times 10 is 100. We're going to make it, we're going to.
Yours where they are, Tom.
All right. So, the PM&R doctor, I will typically use a PM&R doctor, sometimes a neurologist, it depends on the case, to prepare the estimate of future medical costs, commonly referred to as a life care plan. But in front of a jury, I don't call it a life care plan.
Right.
And so the PM&R doctor that you're using to help kind of paint this complete picture of chronic pain syndrome, brain changes that accompany chronic pain, is that usually a retained expert or is that a treating physician?
It can be both. It really depends on the case and where I'm at. But that also gets to another theme, I think, of really good brain injury lawyers, which is you really have to spend the time meeting with these doctors. And, I will tell you, so I've had cases now in 14 states. And the first thing that I always do is I'm calling all the lawyers I know in those states, and I'm asking who are the most patient caring doctors. And it's interesting because you have to meet with them and you have to bring the literature when you go to these meetings and just say, look, this is what I've been reading. Is this something that you believe in, that you can get behind, that you can support? If it's not, then you keep them to their role in the case and you hire forensic experts. I just know from trying these cases that one of the ways that defense is taught to attack these cases is that these are all concocted plaintiff lawyer, treating doctor, big money conspiracy cases. And the more you can get away from making direct referrals, which isn't always possible, I understand. There are some areas of your state or my state where it's just really hard to find good doctors.
Right.
And there are areas in Michigan where it can be a year just to get in to go see a neurologist.
That's a problem we have with neurologists in particular.
Yeah, it is a real problem everywhere. So
somebody's got active symptoms from a TBI that they had 3 weeks ago, and it takes 3 to 4 months at least just to get in to see a doctor.
Right. So, and those are case killers. Those gaps of time delaying diagnosis are case killers. So if that's the case, then you better forensically hire someone and you explain to the jury why you did it. But just know that there are a lot of different ways to make that referral without you directly having your fingerprints all over it these days. Through the Brain Injury Association, through a case manager, through a different treating doctor or quarterback doctor, what have you. There are a lot of things you can do that minimize a defense attorney being, trying to paint everything as this big money conspiracy. But at the end of the day, you got to do everything you can to minimize these gaps of time. Because a jury's going to be saying, if this case really were as serious as you say it is, well, why did it take 6 months to go and get into this doctor? So I think in those cases, the difference between a really good brain injury lawyer and one who's middling and doing a disservice to the client is we are proactive on these cases. We are all over them. We're constantly looking at them. We are constantly touching the client and making sure that they are treating, that there aren't gaps in treatment. That's our role, because the reality is if you depend on the doctors today, especially in this HMO managed care world where it could take a year to get in to go see a doctor, these cases are going to be stillborn. They're going to die on the vine.
I couldn't agree with you more, actually. I mean, if I could only give one piece of advice, it's that one. You've got to make sure your medical records document your symptoms and that your client is actively getting seen by qualified people, like from day one, really. Yeah. Or the case isn't going to turn out well 2 years later when you go to trial on it.
If today's episode helped you see your current case in a new light, share it with a colleague who's facing the same challenges in a case. Subscribe wherever you get your podcasts and join our community of trial lawyers who refuse to settle for average results. This has been Winning the TBI Case. Strategy, science, and storytelling with Tom Crosley.